Afternoon. Once again, thank you for joining us today. My name is Christina Delgado. I'm with the Department of Consumer and Business Affairs Mediation Program. Thank you for your interest in today's topic. Today, we will be discussing the mindset and practices one should have during mediation. Okay, and we do want you to get the most out of this webinar. So at the end of the presentation, there is going to be a Q&A session. So if at any time during the presentation you do have a question, please use the chat feature to type any questions that you may have, and we will answer them at the end of the presentation. You can locate that chat feature by clicking the chat icon at the bottom right-hand side of your screen, and the chat icon should reflect the image that you are seeing right now on your screen. Also, please keep in mind that your microphone will not work during the session. That is why all questions do need to be asked through the WebEx chat. In addition, the webinar will be recorded and will be available on our YouTube page. You can also find previously recorded videos on other topics relating to mediation. We do encourage you to check them out. I will post the YouTube link in the chat box momentarily. Okay, and it is very important for us to provide you with the information that is helpful to you. That is why we do appreciate it if you could complete a short survey when the presentation does conclude. You do not need to select anything. There will be a window that automatically pops up once the presentation and the Q&A session concludes. But now I would like to introduce you to your presenter, Tanzila Hura. Tanzila?
Hi, thank you, Christina. Hello, everyone. A very warm welcome to those who have joined us today. My name is Tanzila Huda. I'm a senior mediator at Los Angeles County Department of Consumer and Business Affairs Dispute Resolution Program. So today's webinar is about the mindset and conduct we expect from mediation participants. We observed over the years that many mediations are not resolved because of the attitudes or some kind of behavior of the parties themselves. This is usually because most people are not familiar with how mediation works. So therefore, I will begin this webinar with a brief overview of basic mediation principles and the role of the mediator. This information will help you understand why we will be making certain recommendations of different mindsets and behavior that we want to see, or best practices. Okay, and after we go with the foundational information, we will go into the main topic. We have a lot of materials to cover today, so let's get started. And thank you again for joining us today. So if you could have the first slide, please. Let's start with what is mediation. A lot of people request mediation without even without doing any research or knowing what mediation is. So let me tell you what it is. Mediation is a structured dialogue between two or more people in conflict. The dialogue or conversation is guided by a neutral third party or a mediator, and the purpose of mediation is to resolve disputes. Next slide, please. Christina, next slide. Okay, so there are three basic principles of mediation. One is that it has to be voluntary, neutral, and confidential. So let's first talk about what it means. What does the voluntary process mean? So next slide, please. For mediations to be voluntary, it means that every step of the mediation process must be voluntary. This means that the two participants must willingly mediate. If a person does not wish to mediate, we will respect that and not try to change their minds. We will not force anyone to mediate if they don't want to mediate. Sometimes clients insist that we threaten their opponents to settle or accept their offers. We cannot do that. Coercion is against mediation principles because, again, every step of the mediation process has to be voluntary. So voluntary process entails the parties make offers and counteroffers and reach agreements freely. Participants have the absolute right to terminate the mediation for any reason at any stage of the mediation process. Even if you come to an agreement and at the very at the very end, when we draft the agreement and you change your mind at the very last step and you don't want to sign the agreement, you're free to not do that. No one can force you to sign the agreement. And again, either party may withdraw at any time. Next slide, please. Now let's talk about the neutral process and what it means for mediation. The mediator facilitating the dialogue must be a neutral. By neutral, I mean the mediator cannot be involved in the dispute, have any relations or relationships with the participants, or have any interest or stake in the outcome. Mediator neutrality fosters trust and confidence in the process and ensures the parties are treated with fairness. Neutral process also means that the parties will not be judged. There is no assigning of blame or fault or guilt in mediation. So in mediation, we're not trying to figure out who is liable for damages. We're not concerned with assigning blame or guilt or even identifying any wrongdoers. I mean, technically, there is no good guy or bad guy for purposes of mediation. There is not necessarily any right or wrong. It is about, a problem that you're experiencing, and we help you come together and find a solution to the problem. Instead of assigning blames, we look forward and try to find solutions. And this is really important because the neutrality part is really, really important because no one likes to be judged. And that's why mediation's neutral platform is so powerful and effective. It welcomes everyone. It embraces everyone, despite what they may or may not have done in the past. It gives them an opportunity to make things right, solve problems, and move forward with their lives. Next chapter, next slide, please. Confidentiality. So let's talk about confidentiality in mediation. This means whatever is discussed during mediation is confidential. For example, mediators may not share information between the parties with the other party without the other party's consent. Mediation communications are private and mediators cannot disclose anything to the public. Simply put, what happens in mediation stays in mediation. Confidential process helps the parties feel comfortable and safe. It fosters openness and frank discussions of the issues. Okay, so let's go to the next slide. So what is the mediator's role? Mediators help parties find solutions to their problems or bring the dispute to an end. Mediators are neutral. This means they are not directly or indirectly involved in the dispute. They must be free of bias and treat both parties as equals and not favor one party over another. They convey messages, offers, and counteroffers between the parties, especially when parties do not wish to be in the same room, they do not wish to speak to each other. So the mediators can really take care of that problem. They can go between, because a lot of times we have disputes with people or we cannot solve problems because we do not wish to speak to the person we are angry with or we're having problems with. So the mediators come into the room and, bring down the temperature and bring peace into the room, and they connect the two sides. So mediators convey messages, offers, counteroffers between the parties. They provide a safe space for the parties to speak without intimidation, coercion, fear, harassment. Mediators cannot give legal advice, offer solutions, or tell their clients how to resolve their disputes. Instead, they will help the parties weigh their options and formulate their own solutions. So it's really important that you understand when you request mediation that mediators are not advocates. They are not there to fight for you. They're there to help you, help both of you. And they do not represent either party. They are there to help both parties. Okay, next slide, please. So participant attitude and behavior determines success or failure of the mediation process. Now that we have gone over the basic mediation principles and the role of the mediator, we are ready to discuss what we want from you when you request mediation, what attitude to bring into the mediation, and what kind of conduct or behavior we expect from you, because these are best practices and it'll help you. It'll go a long way towards resolving the disputes you come here with. And it's really, really important because you play an extremely important role. So let's go to the next slide. Mindset and behavior, self-determination, and party empowerment. This is a concept that I think most people are not aware of or familiar with when it comes to mediation. People mostly think mediation is a mediator who just goes back and forth between two parties and just, so almost like an auctioneer getting the right price. But it's more than that. It's very, very crucial that you understand what self-determination and party empowerment means in mediation. So the first and most important mindset to bring to mediation is to understand that the parties are responsible for finding their own solutions. Mediation recognizes the principle of self-determination based on the belief that no one knows us better than we know ourselves, okay? No one knows us better than we know ourselves. Why should someone else, whether it be a mediator, a judge, or a jury, make decisions for us? We are intelligent beings fully capable of making our own decisions. No one can do this better than us. No one can find a solution better than we can, because we only know what's right for us, and we're the only ones who know what's going on in our lives. If a settlement is reached, the parties must abide by the terms of the settlement and live with the consequences for the rest of their lives. That's why the parties must formulate their own solutions. So what happens a lot as mediators that we see over and over again is that people request mediation and then they say, hey, what should I do? What do you think we should do? Or what's your opinion? Or what would you do if you were in my shoes? The thing is, we can't answer those questions because our lives are different from yours. Our situation is different. Our background, our viewpoints, our personal beliefs, everything is different. Only you know what's right for you. Only you can stand in your shoes. So that's why when you come to mediation, we don't want you to ask us what to do or what our opinion is, because it really doesn't matter. What really matters is what you want to do, how you want to do it, and we're there to help you with that. So when you request mediation, we expect you to come in with the mindset that you understand that you have a duty to take ownership of the outcome. You are responsible for making the mediation a success. You are in the driver's seat. You're not playing a passive role. You're playing a very, very active and crucial role in the success of the mediation. You're responsible for the outcome. You're responsible for coming up and bringing up solutions. And so it's really important that you recognize this. So don't get me wrong, your mediator will help you through this, because you'll be thinking, okay, if I come up with solutions, what will the mediator do? The mediator is there to empower you. That's what party empowerment means. The mediator will help you, will bring up issues, help you to think about different issues that are really important for your case. They will ask you to look at certain issues. They will ask you to reflect on your needs, your priorities. They may ask you to look into your bank statements or talk with your family members to figure out what is best for you. They'll help you with looking at different options and thinking more with a more flexible mindset. So they'll be helping you through that, but the ultimate decision rests with you. Next slide, please. The other mindset we want you to bring with you when you come to mediation is that you bring in, you make a good faith effort to mediate. No, it's the slide before this. Yes, thanks. Okay, so when you request mediation, we naturally assume that you want to mediate, right? Unfortunately, many people submit mediation requests with ulterior motives. They just have a different motive. They request mediation, but it isn't mediation that they really want. So we want to see our clients make good faith efforts to mediate, to find solutions, and bring the dispute to an end. So what does good faith effort even mean? Good faith means to be what one appears to be, okay? To be what one appears to be. It implies trustworthiness and sincerity of purpose. So when you request mediation, we expect that you want mediation. That's really what it means by good faith effort. With your, first of all, with submitting the mediation request, and then secondly, during the mediation process, we expect you to make good faith efforts to participate in the mediation process. So a good way to illustrate what this means is to talk about the opposite of what it is. So let's talk about what the opposite of good faith effort is to illustrate what this really means. So here's an example. A contractor wants to sue a subcontractor for breach of contract. Their agreement requires that they mediate first, and if the mediation doesn't resolve the dispute, then they may file a lawsuit. Okay, so the contract wants to file a lawsuit, but the agreement between him or her and the subcontractor is that they must mediate first. The contractor requests mediation, but when the mediator attempts to begin the mediation process, the contractor ignores the mediator, doesn't return phone calls, doesn't respond to questions, doesn't tell us more about the issues, doesn't tell us what they want, doesn't make any offers. The mediator, suppose, calls and says, let's set up a mediation date. Let's have a video conference. Do you want to come to the office? When do you want to come? Because the other guy wants to mediate. But say, the contractor doesn't give a date, or maybe sometimes these parties, the contractors makes unreasonable demands, such as we've heard people make demands such as, I will settle, this is my offer, I will settle for $500 billion, $400 billion. So from the demand itself, you can say, oh, okay, you know what, the other guy is probably not going to accept that, so this mediation is going to go nowhere. And then what happens? We close the file because, we can hardly move through the mediation process. We don't progress through the different steps, and the mediation file is closed. And the reason being, and what was going on here, was that the contractor never really wanted to mediate. What he or she wanted was a closing letter from us stating that the mediation case is now closed, so they can show that letter to the judge when they file the lawsuit. Okay, so this is an example of a mediation request and a mediation participation which is completely lacking in good faith. And let me give you one more example. Suppose a businessman has a dispute with his business partner, and wants to, they cannot resolve the dispute. There's a lot of animosity between them. They cannot resolve the dispute, but the dispute needs to be resolved. So this person decides, you know what, I want to sue this guy, but then decides, you know what, we worked together for a long time. There's a lot of things he knows about me. There are things I've done that I'm not that, it's not very, it might be a little shady. So I'm not sure if I should sue him, because who knows what he'll come up with. So you're a little, the person's a bit scared, a bit hesitant to file the lawsuit because he doesn't know how much dirt, perhaps some dirt, that his partner may have on him. So suppose this businessman requests mediation, okay? So during the mediation conference, suppose the mediation takes place, and during the mediation conference, this businessman asks a lot of questions, and the business partner answers those questions, thinking that, you know what, at least we'll get this resolved here, and I won't get sued. So the business partner answers those questions as frankly and candidly as possible. Then suppose the business man asks the business partner during the mediation process, I want to see some documents. You said this, you said that. Can you show me some documents that show that this really happened, or this is why you think a certain way? And so the businessman, the business partner promptly shows these documents, sincerely believing the mediation is going well. But when it's the turn for the business partner to ask the businessman who requested mediation asking him to show, tell his side of the story or show his documents, this businessman just, he walks out, he stands up, walks out of the room and says, you know what, I don't want to mediate anymore. Bye. So what this person did was show a feigned interest in mediation. It's a fake interest. It's not a real interest. It was just a pretend, they was just pretending. All this person was trying to do was gather information from the opponent to see whether or not they should go forward with a lawsuit. Okay, so this is an example of a person who requested mediation without any genuine interest or sincere interest to mediate or participate in the mediation process. It was simply a fact gathering maneuver. That's all it was. So why do we want you to make good faith efforts to mediate? Well, first of all, our mediation services are free. We have an excellent crew of highly trained and experienced mediators. We work really, really hard to help both our clients. We read your documents, we prepare, we try to understand what you have to say. There's a lot of investment that goes into this. There's a lot of background work that goes into it for each of the cases that we work on. We also get help from volunteers. They're excellent volunteers from very from diverse backgrounds, and they want to give back to the community. Many of these volunteers are retired individuals who even after retirement want to keep busy and give back to the community, and they want to donate their time to help others. Some volunteers we've had, they've traveled, they travel 2 hours by train or even by bus to come to our office to mediate. Okay, they want to give back and they really want to help. So it isn't fair when their time or resources or our time or resources are squandered by cases which are submitted without any good faith. Okay, so please request mediation only, and only if you really, really wish to mediate in good faith. If you need more information about your case and you're unsure what to do, you can always speak with an attorney. You can speak to a consumer counselor. There are other ways to go about it instead of requesting mediation. Okay, so the next slide, please. So mindset and behavior, optimistic and positive attitude. The attitude of the parties significantly affects the outcome of mediations. There are people who request mediation and then throughout the mediation process will say things like, I really don't think this dispute will be resolved through mediation. I'm so sorry. I think I'll be wasting your time. This whole application, it's going to be a whole total waste of time. He will never agree to mediate. Well, even if he does, I bet he will be lying constantly. So what's the use? Well, even if he agrees to pay, he will not sign the settlement agreement. Even if he signs the settlement agreement, he'll probably never mail the check. Or if he mails the check will bounce. So, so people talk like that constantly. So negative and pessimistic attitude will cause you to not take the mediation process seriously because you don't believe it's going to work. You will go through the motions without being truly invested or engaged if you come with a negative attitude, if you expect it to not work. We want you to come to the mediation with a positive and a can-do attitude. Remember the self-determination theory that we believe in mediation is one of the important principles of mediation, that you can make it happen. You are responsible for making the mediation a success. You, participant, you're responsible. So if you're responsible, then you need to have an optimistic and positive attitude because it's in your control. Mediations are hard enough without negative energy thrown in. So please, when you request mediation, and I know it's not always easy because especially if a problem's been going on for a long time, but please try your best to bring an optimistic and positive mindset when you request mediation. Next slide, please. Okay, so mindset and behavior, future-oriented outlook. We want you to approach mediation with a future-oriented outlook because whatever happened in the past cannot be changed. That's the reality. You have the power to create a better future by resolving your disputes today. You can have a different future if you resolve it now. Bring the conflict to an end and start a new chapter in your life. Okay? We have mediated many cases where the parties were so fixated on the past that they spent the entire mediation conference meeting just venting their anger, rehashing the past, screaming at the other person about what happened, going through blow-by-blow account of what the other person did in the past. And they refused to negotiate, and all they did was complain and complain. Okay, it's very difficult to resolve cases if the parties are not ready to negotiate. So when I say we want you to come here with a future-oriented outlook, we want you to come here with the outlook that you will be negotiating, that and that understanding that it's negotiation requires cool-headedness. It requires you to be patient and do some thinking, some clear-headed thinking. If you're feeling very, very emotional, it'll be hard for you to do that. So once you're ready to negotiate, once you're able to, think like, whatever happened in the past is in the past, and I'm ready to move forward, and I'm ready to look at the future, and I want a better future, that's when you want to request mediation, okay? And I do understand that there's some problems that have been going on for a very long time, and you might be traumatized that people treat each other poorly, and that you might be very upset, you might be very hurt and angry. It's completely natural and understandable. But for purposes of mediation, we want you to come when you're ready to mediate, okay? Okay, so the next slide, please. So mindset and behavior. No adversarial or litigious mindset. When you're ready to mediate, you must leave behind adversarial or litigious mindset. So all the TV shows you watch about, attorneys and all these, was it Law and Order and all of that? Put that behind you, because mediation is a totally different animal. Okay, it's a different beast, and it's a different kind of system. It's a different way of thinking. It's a different mindset. Requires a different set of behaviors. Okay, the goal of mediation is to resolve disputes and not to start a new one. By starting a new one, I mean, it's the goal of mediation isn't to get you to file a lawsuit. Okay, the goal of mediation is that you will not file the lawsuit, or if you have filed a lawsuit, you're going to settle it and dismiss the lawsuit. Okay, that's what the mediation is for. So a lot of people participate in mediation, but they keep saying, well, I will tell you, during negotiation, we say, oh, okay, I will tell the judge this, I will tell the judge that. Oh, well, we mediators, we're preparing you and helping you to not go to court, not go talk to the judge. So if you're in that mode, I will tell the judge this, I will tell the judge that, I'm going to file a complaint, I'm going to, I'm gathering evidence. I heard a couple of weeks ago, the guy saying, I'm going to hire a private detective. We're negotiating and we're trying to settle this matter today. And you're saying you're going to hire a detective to find dirt on the other guy. So that's the kind of attitude that doesn't help with mediation, because the goal of mediation is to resolve it, to bring it to an end, to close it, not to keep it open, not to keep it festering, and not to keep it going on. So please, no adversarial or litigious mindset or intentions. Try your best to just mediate and put the matter to an end, and be mentally prepared that what you're trying to do is not go to court. Okay. And next slide, please. Mindset and behavior. So this is really, really, really important. Mediation is a collaborative process, okay? So when you come for mediation, you need to understand that, and you need to be prepared that you're here to collaborate. The whole thing is collaboration, okay? It's a cooperation with your mediator. It requires your active engagement in formulating solutions. You're not doing that in a vacuum. You are engaged with the mediator and the other person in formulating solutions, and also you have to come up with a mutual agreement. Mind you, it's not an agreement, it's a mutual agreement. So we would like you to approach mediation as a joint venture. Think of it as a collaboration with an opponent to find a common solution. It requires you to engage in teamwork with your mediator and your opponent, okay? Teamwork is the key. You have to be mentally prepared to be cooperative. Now, some of you might be thinking, why should I work with my opponent? He's a terrible person. I'm the good guy. He's the bad guy. And I have to, work with him, cooperate with him? Why should I cooperate with him? Well, the problem is that the problem is that with this kind of mindset is that to resolve a mediation, you need an agreement. And for the agreement, both parties must agree to the same terms. Same. At the end, the terms that you agree upon has to be the same. And it can only happen with talking to each other, collaborating with each other, cooperating with each other, and communicating with each other. So it's a process where you have to discuss all the issues, work through your differences, and finally come up with terms that both of you can agree upon. So it's not a one-step process, it's multiple processes. And so only those terms that both parties agree upon can go into the final settlement, okay? So there is an interactive process to settling disputes. And that's why it's a collaboration. So let's go into further detail. Next slide, please. Cooperation with your mediator. We want you to cooperate with your mediator. Simple, like it sounds like a simple enough advice, but you know, it can be really hard sometimes to get parties to cooperate with us. Even people requesting mediation, lots of them do not cooperate with us, and the mediation goes nowhere. So let's go more into this. So lots of cases are not resolved because the parties do not cooperate with or respond to their mediators in a timely manner, or they don't respond whatsoever. For example, there are clients who don't return phone calls or respond to our emails. Sometimes we may need information from you to verify something. The other party might have questions for you that that need to be answered before they can make an offer or accept your offer. We might need to finalize some terms, like the date you will make the payment. How will you make the payment? Will you mail it? Will you pay with credit card? We need you to answer questions because we don't know those things about you. We need you to tell us those things. We can do these things if you're not able to get in touch with you. Remember, mediators cannot make decisions for you. Okay, self-determination. You will make the decision, and you need to provide us with information that we may need. Sometimes we may ask you to consult with an attorney or seek consumer counseling to make better informed decisions and choices. Since we mediators, we cannot give you legal advice or tell you what to do. We may sometimes ask you to speak with someone else to be better informed. And we do need to communicate that to you, and we do need you to please listen to that, because it is for your own good that you make the best decision for yourself. Sometimes we may need you to provide documents. For example, if you want to do a debt settlement mediation, one of the first things you have to do is fill out a third-party authorization form that has, you need to put in your birth date, your social security, it needs your signature. It's a simple form basically asking for 4 or 5 pieces of information. And so many debt settlement cases are not resolved because the person who submitted the request doesn't respond, doesn't read their emails, doesn't fill out the form, doesn't send it back to us. And so these cases just get closed. They're simple cases that could have been resolved, but they're not because the parties are just not communicating with us. If an agreement is reached, we will draft the agreement and ask you to review it with us. I've had clients, like I call them and I say, hey, we have an agreement. I want to read it out to you. They're like, oh, no, I don't want to hear it. I don't want to hear it. I'll just sign it. And I'm like, no, I need to read it out to you. This is your life. It's going to affect you. A lot of people like that, they don't want to, had people say, okay, let me just sign the agreement form. And I say, hey, I haven't even written it. What are you going to sign? What are you signing for? So we want you to cooperate and listen and make informed choices. And when we ask you to do something, there's a reason for that. We're trying to help you. We're trying to help the other side. So it's important that you maintain contact with us. It's especially important that you respond in a timely manner if there is a pending lawsuit, okay? Time can be of the essence in certain mediations. Some things, there might be no urgency, but some cases there is a lot of urgency, especially if there's a court case. Next slide, please. So active engagement in formulating solutions. This is part of the collaborative process. You cannot be a passive or silent participant in mediation, okay? So it's, like you submit a mediation request, we just don't go out and get that for you. Like you want somebody to pay you $10,000. We don't just take your application, call the other guy, or and just go grab the 10,000 and give it to you. It's not like that. There is an engagement, there's an active participation and a lot of action that is required from you. We will ask you to make offers and counter offers. We may ask you to think of alternate solutions or sometimes think outside of the box when we're stuck. We might need you to do some research. We might ask you to, like I said previously, talk with an attorney, call the consumer counselor. We might ask you to examine your finances or speak with your supervisor or speak with your spouse. Remember that mediators won't make decisions on your behalf or tell you how to resolve the dispute. Okay, you have to do it. The mediator will guide you, but you have to play a very, very active role in doing so. Next slide, please. Mutual agreement. Sometimes parties refuse to mediate, but the other party will say, but I'm here. You can mediate with me. I'm ready to settle. We don't need him. Unfortunately, we can't do that. You cannot mediate with yourself. I've heard clients say things like, I have no interest in hearing what my opponent has to say. I don't care what he wants. It doesn't matter what he wants. I'm the victim here. Don't tell me what he wants. Just give me what I want. So you cannot have a unilateral agreement. You cannot impose your will on the other person. The only terms that go into an agreement, the final agreement, the only terms that will go in there are terms that both parties have agreed on. A resolution will only be reached if both parties agree to the same solution. So if you want to reach an agreement, be prepared to deal with the needs of your opponent. You cannot disregard or ignore the other side. You must be willing to hear what your opponent has to say, their side of the story, understand what they want from you. This is a two-way street, okay? It's a two-way street. There must be some give and take. You two are in it together. You must be willing to be part of this interactive and dynamic process. Now, I understand you may not want to communicate directly with your opponent, or you may not want to be in the same room with them. So we have a solution for that. The mediator can place you in separate rooms or do a video conference or a three-way phone line conference. So there are ways to get around it. We understand you may not want to deal with that person. We will deal with that person for you, but we need you to be part of it and play an active role in it. So mediators are messengers. You can speak to the mediator, and the mediator will go back and forth between you and relay messages, convey offers and counter offers, and ask questions on your behalf. If you recall, I said earlier that mediators are not advocates and that there can be no coercion in the mediation process. So please don't ask your mediators to make threats on your behalf. Don't ask them to pressure your opponent to accept an offer they don't want to accept. Mediators must maintain neutrality and respect party self-determination and free will. So that's the basic information there. And let's go to the next slide, please. Mindset and behavior, flexibility. We want you to approach mediation with a flexible and open-minded attitude. We know you requested mediation because the other side wouldn't comply with your demands. What makes you think that they will comply with your demands in mediation? What changed? When mediation has a strict no coercion rule, it encourages party self-determination, okay? So they didn't listen to you before you requested mediation. And so during mediation, why should they listen to you? Because mediation doesn't allow coercion. Mediation doesn't allow us to pressure the parties. So how can you expect things to change in mediation when there's no coercion? So the key to resolving disputes is to keep an open mind, being open to changing your position and your demands, being willing to take less money or give more money for the sake of bringing the dispute to an end, being open-hearted. You will find that stubbornness and inflexibility are major roadblocks to successful mediation. Next slide, please. Compromise. Now, first of all, before we even talk about compromise, let's talk about something else. Conflict is inevitable. Since no two people think alike or want the same things or feel the same way, conflict will always arise with people you interact with good people, with your family members. Even if you have pets, they fight with each other. If you are around somebody, something will cause some kind of disagreement because no one is alike. Okay, people want different things. So it is a reality of human life and human existence that you cannot separate conflict from the human experience. It is a reality of human life, and you have to accept that. Since conflict is a natural part of life, the wise thing to do, or maybe the wiser thing to do, is to accept it and find a solution. Don't just live in conflict, find a solution. Conflict is time sensitive. The longer you wait, the worse it may get. So compromise is one of those solutions that no one likes to hear about, but it's important to hear about it. When you compromise, you may give up some of your demands. You may accept less money than you initially wanted, or pay more money than you originally offered. The benefit of compromising is that you bring the dispute to an end, you close the chapter, and you move forward with your life. Compromise is especially important in situations where the parties cannot agree to certain terms. You're locked, you're just gridlocked, and you can't move forward, you're stuck. That's when it's really important that one of you compromise, because if one of you doesn't compromise, the mediation will fail. There'll be no solution, and you end up in court. So compromise is really, really important. Okay, so come to mediation with that in your head, that, you know what, I might need to compromise, and it's good for me because I'll bring it to an end. Since there will be no meeting of the minds, compromising may be the only way to resolve a dispute when things are stuck and things are not moving forward. Next slide, please. And so mindset and behavior: do not escalate the conflict. Give peace a chance. So this is the last piece. Mediators are peacemakers, and mediation is about ending conflicts by finding some solution to the problem. Okay? Peacemaking, that's what mediation is about. When you are participating in a peacemaking process, you yourself become a peacemaker. Okay, so we want you to recognize the role you have when you take part in mediation. Okay, you're trying to be a peacemaker yourself, although you may not realize that. So we expect you to act in a peaceful manner. For instance, be patient, okay? The interactive back and forth nature of mediated settlements can be hard and may take time. So please be patient with yourself, with your opponent, and the mediator. Do not undermine the process. For example, some people will rehash the past after a solution has been found. It keeps the conflict cycle going. And what is the point of that? Okay, your goal should be to get out of the conflict cycle. So a lot of people use abusive language. They insult people, they say horrible things during mediation, and then, you know, they just escalate the conflict. Whatever problem they had before mediation, they make it worse by the things they say or the things they do. I've had clients who have like, we're mediating, we're reaching an agreement, and then after the mediation is over, you know, that same night, the client goes over to the opponent's house and starts screaming and fighting, or they're calling or sending nasty text messages. What's the point of that? You know, you're trying to resolve the conflict. Why are you escalating? Why are you reopening the old wounds? So do not escalate the problem. There are people who will tell us, I will give him the $10,000 that he wants, but I want to give him a hard time first. I want him to beg for it. I won't make it easy for him. So they're telling us right in the very beginning, yeah, I'm going to give him, you know, the thing he's asking for, I'll give it. But you know what? I'm going to make it really difficult. I'll make it really slow. Like I've done mediations where the person, where during the bargaining process, the negotiation process, the person is going by, okay, I'll give him $205. The other person rejects, says, okay, I'll give him $210. And it goes on for hours until they reach the amount that the person was or thinking, secretly planning to give anyway. So why make things difficult? Why aggravate the other party? So I would also like you to consider some other peacemaking tactics, such as forgiveness, letting go of the past, taking ownership of the conflict, and perhaps recognizing that you may have played a role in creating it in the first place, apologizing, showing vulnerability, expressing remorse, expressing appreciation, and even expressing gratitude. So that's all I have for you today. And I hope you found this lecture, this webinar helpful.
Okay, thank you, Tanzila. And that was very helpful information. And thank you all for joining us today. We will answer your questions momentarily. I do want to inform you that if you want to learn more about our mediation process, or if you want to submit a mediation request, please visit our website at dcba.lacounty.gov, or you could give us a call at 1-800-593-8222. I will put that information up momentarily. But having said that, we are now in our Q&A session. If you have any questions, once again, please use the chat icon located at the bottom right-hand side of your WebEx page. We'll give you time to type in those questions, but in the meantime, we will answer the first question. Tanzila, we do have the first question is, how do you know that the mediation is at an impasse?
Oh, well, you'll know because there's no agreement. two parties want two different things. For instance, a party wants $10,000, the other guy is offering only $300, so there's no agreement, there's no meeting of the minds. Basically, like I talked about, mutual agreement, the number or the solution they're coming up with is not matching. It's different. It's totally two different things. So that's when it's in an impasse, because it's not going to go forward into settlement because they do not match. They are different.
Okay, thank you for that. We do have another question. What if we have a clause that says mediation is mandatory?
Yeah, if there is a clause and that says mediation is mandatory, you're welcome to mediate. You have to mediate because, and I'm assuming you mean the clause says mediation is mandatory before filing a lawsuit, or that only mediation is the way to solve it. I don't know which exactly you have in mind, but suppose you have an agreement that says that mediation is mandatory before filing a lawsuit. Then, like I was speaking about it earlier, when you're requesting mediation, give mediation a chance. Make good faith effort, because there are other lectures about this. We didn't cover that in detail here, but like I was talking about, the adversarial process, which is the litigation process, is expensive. It's time consuming. It's very formal. There are formal rules of court. There's rules of evidence. Not everything can go into the courts. When you're litigating, not everything can go into court and it cannot go into evidence. Whereas in mediation, you discuss what topics you want to discuss, what issues you want to cover. And it's informal, and our services are free. We have excellent mediators. So when you request mediation, we would like you to mediate and try to resolve it and not go to court, because in my opinion, I think that mediation is a better way to resolve disputes. The other thing is, if suppose the clause says mediation is mandatory and there's no other way to solve it, this is the only way you have to agree to solve it, then yes, try mediation. And the thing about it is that suppose you try mediation, you don't resolve it, you can always request another mediation and try it again. Because sometimes we this happens a lot. People request mediation, we try to do it, and it doesn't get resolved. Then a few weeks later, a few months later, the same people request mediation again because they've had time to reflect on it, they had time to think about it, and then they're like, you know what, I think I should try this one more time. You might have a change of heart and you may find a solution. So usually I've seen people who come back a second time, they're able to resolve it.
Okay, thank you, Tanzila. Next question is, I have over 100 pages of documents for you to review. Does the mediator need all those documents?
No, no. I hope you don't have 100 pages for us to review. And no, we don't. What I do is, I mean, first of all, it's not very helpful in the mediation process, because it's what we're trying to do is, and it goes back to the difference between the mediation process and an adversarial court process, where in court you have to go through those documents, right? If you're filing a lawsuit, the other side, there's discovery, they have to go through the evidence. So it's really important to go through everything. Whereas in mediation, it really isn't. Whatever, like I said, whatever happened in the past happened. It's future oriented. So we usually tell people, like, when people do send us documents like that, 100 pages, 60 pages, I tell them to just summarize it for me. Just tell me in your words what's in there and what it means, just like really, really brief, because the whole idea is to solve a problem, not examine the problem that detailed and figure out what's right, what's wrong. It's not an investigation. It is a looking forward towards a solution, asking you for offers and counter offers. Okay, so a basic goal should be making an offer and thinking about what the other person's counter offer is, and trying to find a solution. Okay, so those documentations, yes, those are important. They'll be very important if you do end up in court. But in mediation, it's important, of course, because that's what brought you to mediation. But that's not really how this process works. Our process is more about solving the issues. Okay, we're not investigators.
Okay, perfect. Thank you. Next question. I fear my landlord won't want to mediate. Should I bother trying to mediate?
Yes, you never know. Lots of people refuse to mediate. And so what our job is really, and I'm a big believer in that, is you request mediation, and then we contact your landlord. And we will be sending them our first contact with your landlord will be by letter. We will send them your mediation request. Plus, we will give them a packet. It'll have information about how our mediation program, how to contact us, how to log into our portal so that they can do online messaging, send online messages to the mediator. And it also has a sheet that explains what mediation is, the benefits of mediation, what can and cannot happen in mediation. So it's an informational packet. And so then we call up. If your landlord doesn't respond to us, say in a couple of weeks, then mediator will be assigned, and the mediator will call your landlord. So in your application form, it's really important that you give us your landlord's email and phone number, and then we'll call your landlord and we'll tell them so and so wishes to mediate with you. Maybe your landlord will say, no, I don't want to do it. This is, we can say, okay, just give me 5 minutes to explain the benefits of mediation. So we can try to explain the benefits of mediation. One of the big benefits of mediation is that if you can resolve the conflict now, that conflict comes to an end. You don't have to worry about getting sued. You don't have to go to court and spend money and add stress to your life. You can end it today. So we will discuss these things with your landlord and try to persuade them to participate. I mean, that's the most we can do, is try to convince them to take part in the mediation. But like I said earlier today, that it's a voluntary process. They may not want to mediate despite what we tell them, and we have to respect that, because we have to respect their free will. And so, but most of the time, people do agree to mediate once they talk to the mediator and find out how the mediation process works. So yes, please send your application.
Okay, thank you. And then next question, what if the other party breaks the agreement? Can you make them do what they promised?
No, we can't. Again, mediation is a voluntary process. Suppose you come to an agreement and the person doesn't send you the check. Okay, suppose they agreed to send you $500 by a certain date and they don't send it. What we could do, at least in the beginning, what we could do is just make a courtesy phone call to the other guy and say, hey, we reached an agreement the other day. You were supposed to send the money. He said he hasn't received it, and just give a friendly reminder. And sometimes that's just enough. Other times they may not do it. Then some people try another mediation. Some people go to attorneys and ask them to write demand letters. Some people, we could also connect you to our small claims advisor, and they can talk to you, or a consumer counselor who can talk to you about your other ways to enforce the promise, enforce the contract. So there are other ways. Our department has so many other units that could be extremely helpful to you.
Okay, thank you, Tanzila, and thank you all for your questions. We'll give you a few moments just in case there's any last questions. Let me see. And if we didn't answer any of your, we didn't answer your question, or if you could think of a question after, we do have our information posted up right now. Please call us or visit our website to learn more about our program, or if you have a question. Okay. Okay, so those are all the questions for today. We hope that this information was very helpful to you. Once again, please go ahead and visit our website if you have any additional questions, or if you would like to know more about our program. Tanzila, thank you so much for all the information.
Thank you,
you
Christina,
all
and
for
thank you
joining
to
us.
all the attendees. Thank you very much for attending today.
Thank you. Bye.